My name is Scott Pearson. I'm currently a judge at the Reno Justice Court. I had the honor and privilege of judging this competition now for several years.
Good afternoon. Thank you for allowing me to be here today. I'm Emily Meyer. I'm the Washington County Public Defender, and this is my second time judging.
I'm John Andrews. I'm the retired Chief Deputy Attorney General, and I'm a Supreme Court settlement judge. I've judged the state and regional competitions frequently, and I've twice judged the national competition.
Well, as you know, this is Unit 5. You know, Unit 5, which is what rights does the Bill of Rights protect. We have chosen for you question number 1, which is, why have First Amendment rights been viewed as essential to the functioning of a free society? Answering that question, please address the following. In what ways have these rights been of particular importance to women and minorities? And also, although First Amendment rights are considered essential in a constitutional democracy, it is sometimes argued that these rights must be limited. Under what circumstances, if any, do you think limitations are justified? Please explain your answer. You may begin when you're ready.
Justice Oliver Wendell Holmes wrote in 1919 dissent in Abrams v. United States, persecution for the expression of opinion seems to be perfectly logical. But the ultimate good desired is better reached by free trade in ideas. That the best test of truth is the power of the thought to get itself accepted in the competition of the market. The rights granted by the First Amendment are essential to the functioning of a free society because they protect individuals' rights to freely contribute to what Justice Holmes called the marketplace of ideas, ultimately fostering a sense of liberty and freedom among the populace.
UN Ambassador Adlai Stevenson defines a free society as one where it is safe to be unpopular. Under British common law, citizens did not have the right to submit unpopular ideas to the marketplace. Although there was no prior restraint, after publication, the British government was able to restrict what it deemed seditious libel. In 1734, Peter Zenger was arrested for publication of libel. His lawyer argued that the censorship created a society that was inherently not free. Zenger's victory paved the way for the inclusion of the First Amendment and promoted the fundamental values of liberty and freedom, fostering a more progressive society. Furthermore, the freedom to express unpopular ideas was upheld in the 1989 case, Texas v. Johnson, where the burning of the American flag, although inflammatory, was deemed political speech and was thus protected under the enumerations of the First Amendment. This decision allowed individuals to express ideas that ran contrary to popular opinion, the key to the function of a free society.
Through the protections granted by the First Amendment, women and minorities have been able to create political change and gain the liberties not directly granted to them in the Constitution. During the Civil Rights Movement, the use of the press to reveal to the American people the denial of the right to assemble of African Americans allowed the ideas the civil rights leaders advocated to be added to the marketplace of ideas. The Birmingham Children's March was directly responsible for desegregation in the South and paved the way for the Civil Rights Act of 1964. In the majority decision of the 1984 case, Roberts v. United States, J.C., the courts decided that the freedom to association is a corresponding right to associate with others in a pursuit of a wide variety of political, social, economic, educational, religious, and cultural ends. The right to association, while not directly stated in the First Amendment, has also been important to minority groups like the Native American Rights Fund, who use the power of association to come together and influence government policy.
Women like Alice Paul, activist and founder of the National Woman's Party, exercised expressions of freedom of assembly such as the 1917 picketing of the White House. By exercising the rights given to them in the First Amendment, women minorities have been able to add their own ideas to the public exchange that would eventually lead to political change, resulting in greater access to rights. When speech has an immediate negative effect and gives the marketplace of ideas no time to correct these fallacies, it must be limited. The freedom of religion is also subject to time, place, and manner restrictions, and allows the freedom to ignore generally applicable laws designed to protect the public welfare. In the 1990 case, Employment Division v. Smith, the use of the drug peyote remained a violation of the state law despite the fact that it is used in a religious ritual.
Limitations placed on First Amendment rights are only justified when the limitation is necessary to the democratic society and the function of the marketplace of ideas. The government must have compelling interest in limiting speech before any such limitation should be
very much for your testimony. We now, as committee members, will have a few follow-up questions I'll begin. Oftentimes, people use labels positive or negative rights in explaining the rights and civil rights. Can you please describe for me what the difference is between positive and negative rights and give some examples?
Negative rights are things the government cannot infringe upon. Just like in the First Amendment, we see Congress shall make no law. That's a negative right.
Positive rights are rights that the government gives us, such as a positive right would be our right to vote, which is given in the 19th, the 15th, and the 26th Amendments.
Another example of a positive right would be our right to a trial by a jury, as talked about in the Seventh Amendment in regards to civil cases, and also as discussed in the Fifth Amendment, and talking about grand jury indictments as well.
Thank you.
I believe that both Gigi and Kat began talking about this, but if you can expand a little bit more on conditions under which there can be restrictions placed on freedom of expression and what justifies those limitations. I believe I heard you mention the limitation on time, place, and manner. Are there other restrictions that you can discuss with us today?
So in Brandenburg v. Ohio, which actually overturned Schenck v. U.S., they established that if words inspired imminent lawless action against anyone who would essentially causing harm or violence, they could not be spoken. And additionally, in Chaplinsky v. U.S., they established that fighting words or words that had no apparent value were also not protected under the First Amendment.
However, these limitations only go so far as the government can't limit speech based on content or viewpoint. In the case of the city of Skokie v. the National Socialist Party of America, a group of the National Socialist Party wanted to break through what was a largely Jewish suburb of Chicago, which placed very considerable concerns because of the fact that they promoted a very anti-Semitic viewpoint. And however, even though this viewpoint was not something that the government necessarily wanted to advocate for, it wasn't able to limit their march because their march didn't threaten that imminent danger that my colleague Jacob talked about.
How does freedom of expression contribute to individual liberty? Why is free speech important?
Free speech is important so that people are allowed to express their personal opinions, and without free speech, you would not be able to have your own opinion when it comes to talking to other people or expressing yourself in political sort of things and stuff like that.
In Louis Brandeis's concurrence in Whitney v. California, he said, "The freedom to think as you will and to speak as you think are indispensable to the spread and discovery of political truth." So we can see how this relates to the marketplace of ideas, because it allows us to speak out against our government policies, to change our government, and to educate our fellow citizens.
Great, thank you.
I believe that in your response, as a team, particularly for Jacob in responding to Judge Andrews, you began to speak a little bit about the philosophy underpinning the First Amendment. Can you speak a bit to the way in which the First Amendment rights are based on a natural philosophy view?
Natural rights philosophers believed that everyone had inalienable rights, individual rights, and this was different from the classical Republicans who believed in the common good. So under the First Amendment, we're guaranteed these individual rights over the common good of America as a whole, but really these are individual rights.
And this freedom of expression as defined in the First Amendment gives way to this essential liberties that we have and these fundamental rights that philosophers talked about with the life, liberty, and pursuit of happiness or property.
So you were talking about the limitations on speech and that things that advocate violence that are disruptive, that can be limited. Does that apply to political speech?
Political speech essentially lies at the very heart of the First Amendment and was what the First Amendment really was created to protect because of the situations going on at the time of the framing of the Constitution, especially in regards to the Revolution. And we mentioned the case of Peter Zenger in our testimony and how that political speech that he had was limited. So when it comes to political speech is protected a lot more
they actually found that the media, there was a talk show host who actually was using political speech, although he was being obscene, using a great deal of words that weren't necessary. And so in this case, they actually said that he could be limited because he was on the radio reaching so many people. And the speech, although political, was quite obscene. And so they could limit it.
You could also see this limitation in political speech in Bethel v. Fraser, and although his political speech was a school political speech, it was still vulgar and lewd and required it to be unconstitutional.
So in speaking of language, let's look at the language of the First Amendment as it relates to religion. It states, the terms are, Congress shall make no laws respecting an establishment of religion. Do you think that's a negative connotation?
I wouldn't say that it's a negative connotation, mainly because of the fact that we've come to interpret the establishment clause in 3 different ways. First, dealing with a narrow view, second with a broad view, and third with a literal view. And because of these different views of the establishment clause, you can see that there really isn't, in particular, a actual hostility, I guess you could say, towards religion specifically. It's more towards limiting government and limiting government involvement in religion.
However, historian Nathan Punitz actually argues that this does create a sort of hostility towards religion because it separates church and state so much that people feel averse to engaging in religion in order to also participate in their political process and be part of the government of America. Thank you.
Excellent. Well done. Difficult having this room. It's difficult to command a room this large. Can be intimidating and imposing. You did a very good job with that. This room also, the size of it, the amount of people that are here, also breeds into the expectations that you have at your school because in the last few years you've developed an incredible program. Your teachers done an amazing job, and I know you feel as fortunate as I do for you that you have this opportunity. Great coaches, obviously, that spend the time with you, your parents, and I can see from the support in here, and but most importantly, the time you have taken to dedicate to this. You really look like you enjoy. I was thinking, they should televise this. It's really that awesome, for the community to see, because I just don't think they realize it. Boy, not only does it make the community feel good, we put all sorts of other garbage on TV. Why can't we put something good like this? But it also is informative. Your opening remarks and the way that you constructed them, and we have 3 attorneys up here, so there's a lot of education in writing and constructing arguments, and in fact, how to do legal briefs in a persuasive way. We have been instructed significantly on that, and you followed all of those best practices or tenets of being able to make a good, solid, persuasive argument, informative about something. You explained the terms, you gave examples, supportive arguments with cases. I mean, you did all the things that you're supposed to do, and I was very impressed by it. On the follow-up of my answer, the positive rights, you did a great job. The supporting each other, good use of the hands and the inflection. I mean, again, in those opening arguments and even the follow-up, sometimes it can, and it didn't. You kept it going because you were so happy and so passionate about the subject matter. One final thing I'll say is, I told the group earlier today, boy, they're sure ready for college. And I hope as an alumni of UNR, this is where they come. Not for you guys. You're ready for law school already. You're ready.
Just to follow up on what Judge Pearson just said, I actually had written down IRAC, which in law school is the issue, rule, application, conclusion, and I heard it in your opening statement. I was like, oh, IRAC exam, oh, and then part 2, and I'm so excited just to hear it, because sometimes I think that it can feel like you're That would be the one thing I would take moving forward. Thank you so much.
You guys are very smart. Very articulate. You worked incredibly hard. You did all the cheat tricks, looking at each other as looking at whoever was speaking, which focuses attention on that person and creates the illusion that what they're saying is important. To that, several times, one or more of you would nod to say, this is really significant. And those subtle clues, your audience, picks up on. Body language, you've learned to keep your hands clasped, which it took me a long time to learn to do. FCC versus specific. I was counting in my head. I've done, judged well over 100 teams over the years. No one has ever brought that case up. That is one of the most important First Amendment cases. It's, I can see people who are familiar with it. That's the radio broadcast of George Carlin's routine of the 7 dirty words you can't say on radio or TV. But it's a terrific First Amendment case because there's so many, are there 6 or 8 different opinions in that? No more than 3 justices agree about anything in that opinion. It's a terrific case. And I don't know how you ran across it, but well done. Although my one comment is not criticism, and it's something that you all know but you have forgotten. You have to breathe. During opening statements, none of you breathe, not even the ones who were just watching. Oxygen is really important. It makes you think more clearly. If you pause to breathe, it makes people think you're thoughtful. Remember to breathe, and I'm sure your teacher told you this a dozen times. Those of us that have had to stand in front of the Supreme Court and lock our knees and